Good morning, this is your Kelso Report for Wednesday, December 5th. I'm your host, Clark Kelso. Only two cases today. The first is a Takings Clause decision from the United States Supreme Court, and the second case involves the jurisdictional limits of the bankruptcy court. The United States Supreme Court's Takings Clause jurisprudence tends to be long on rhetoric and evocative verbiage, but rather short on clear, predictable rules. A few certain things are clear, such as a permanent physical invasion of someone's real property constitutes a taking. But move away from that one example and things very quickly become murky. In Arkansas Game and Fish Commission versus United States, the United States Army Corps of Engineers had periodically, from 1993 until 2000, authorized flooding that extended into the peak growing season for timber on forest land owned and managed by the Commission. Cumulative in effect, the repeated flooding damaged or destroyed more than 18 million board feet of timber and disrupted the ordinary use and employment and enjoyment of the Commission's property. So the Commission sought compensation under the Takings Clause. The Federal Circuit Court of Appeals found in favor of the government, holding that compensation may be sought only when the flooding is a permanent or inevitably recurring condition, rather than an inherently temporary situation. Well, the Supreme Court unanimously rejected this simple, clear rule. According to the court, deliberate recurrent floodings, even if of finite duration, are not categorically exempt from Takings Clause liability. Instead, the lower court should examine the takings claim using the usual range of factors, including the time and duration of any physical invasion, whether the invasion is intended or foreseeable, the character of the land at issue, and the owner's reasonable investment-backed expectations, and the severity of the interference. Supreme Court remanded the case back to the Federal Circuit for reconsideration in light of the full set of factors applicable to Takings Clause claims. And our second case from the Ninth Circuit involving bankruptcy court. Now, as you know, bankruptcy courts are presided over by non-Article III judges. That is, bankruptcy judges do not have the structural protections of life tenure and irreducible compensation, which are the hallmarks of our independent federal judges. Because bankruptcy judges are not Article III judges, the issue periodically arises whether particular types of claims are resolvable by bankruptcy judges, or, instead, must ultimately be decided by federal district court judges. In In re Bellingham Insurance Agency, the Ninth Circuit faced this issue in the context of a fraudulent conveyance claim brought against a non-claimant to the bankruptcy estate. Although Congress had declared fraudulent conveyance claims to be core bankruptcy decisions, the Ninth Circuit held, following two U.S. Supreme Court decisions, that such claims clearly fall outside the constitutional jurisdiction of a non-Article III court. And so, a bankruptcy court may not enter a final judgment in such cases. However, the Bankruptcy Code does authorize, and this is constitutional, bankruptcy judges in these type of cases to go ahead and hear and determine the matter and make a recommendation to the district court, which then can review the case de novo and decide whether to enter a judgment on the bankruptcy judge's recommendation. That preserves the Article III as the final decision maker. And in addition to that, the Ninth Circuit panel held that a litigant may waive the right to an Article III court, which the defendant actually did in this case by failing to insist upon an Article III judge until the case was on appeal. So in this particular case, the court said the bankruptcy judge's decision was final. On the merits, the court affirmed that decision. That's it for today's Kelso Report. Have a great day in the law.